Thank you, Senator Warren. The chair recognizes Senator Van Hollen remote if his camera's on. If not, Senator Smith from her office. If not, Senator Warnock from his.
I'm here, Mr. Chair, from my office. Thank you.
Senator Smith from Minnesota is recognized. Sounds like your voice.
Okay, great. Thank you so much, Mr. Chair, for this hearing, and thanks so much to our panelists as well. I want to talk first about this issue of secret outcomes in these arbitration proceedings and what impact that has. You know, as we've been discussing, consumers face significant obstacles before they can have their case heard in an arbitration proceeding. But we shouldn't forget that even if a consumer beats the odds and wins an arbitration judgment, there's often no guarantee that the company will actually change their bad behavior, because the results of those arbitration proceedings are rarely made public, and then the company may have incentives to settle the individual claim without addressing the underlying issues. And furthermore, other companies engaged in similar behavior don't even have the opportunity to evaluate whether they should change their practices or to reduce the risk of future liability. So I'd like to, this should be to, I guess, to Ms. Gillis. Could you discuss how these secretive outcomes of arbitration proceedings can help perpetuate these unfair corporate practices?
Thank you for the question, Senator. I think that the secret hearings are a problem for all the reasons that you stated, but I'd like to add one more. It's not just that these arbitrations happen in a closed vault where we don't know anything about what happened in the arbitration, and so we don't know if the company's going to change its practice or if other similarly situated companies will do the same. The reality is that very smart lawyers, as Senator Warren said, have drafted arbitration provisions that prevent an arbitrator from entering any kind of award that changes policy. The typical arbitration contract these days says that the arbitration provider can only resolve the claims of the individual, cannot resolve the claims of others who might be affected by the same wrongful behavior. So these claims are single-filed, and they're siloed, and they're secret, which is sort of the exact opposite of the way our judicial system works, right? Which is public. We have access to what's happening in a courtroom, into the facts of the case, and judges are authorized to order broader relief, not just relief to the individual, but to enjoin a company from engaging in future misconduct. All of that is missing in the arbitration regime.
Right, right. So it's as if there was a, if this was in court, it would be as if there was a finding in court, but it only applied to that specific case and not to any other incidences of that misbehavior. And at the same time, nobody else was allowed to even know that finding had happened. And so there's the justice isn't perpetuated; it's actually stopped by the secretiveness of these proceedings.
Yeah, exactly. So it's really hard to imagine how people on the other side can say that this is an efficient system. This is the exact opposite of an efficient system.
Right. Well, it's an efficient system if you're trying to minimize your cost,
right.
But not an efficient system if you're trying to maximize consumer protection. Let me just follow up on one other thing. This is around issues of equity. According to the Pew Charitable Trust in Minnesota, Black Americans are twice as likely to have a payday lender near their home in comparison to the rest of the population. We've talked about this in this committee before. Minnesota, 8 out of 10 payday loans aren't repaid when they come due, which then, of course, traps borrowers in a cycle of debt that can end up costing them thousands of dollars. And on top of the predatory nature of these, the Consumer Financial Protection Bureau has found that 98.5% of payday lenders also impose arbitration on borrowers. So we know that many people get payday loans who are already in a precarious financial situation, and a lot of these folks are low income and are unlikely to be in a position to have the time or the money to fight for their rights as consumers. So let me just maybe direct this to Mr. Bland. What type of impact do you think these clauses have on on lower income borrowers, these forced arbitration provisions?
Senator, the clauses are devastating to low-income borrowers. I've represented a number of people who have been scammed by payday loans. You know, payday loans, Pew did a study in which they called payday loans essentially a failed product, by which they mean that the vast majority of consumers who undertake these think it's going to work out one way when they go in, and then it works out dramatically different. And something like 95% on average of the loans end up being rolled over. So you have a ton of people who borrow $250 and ultimately pay out $1,000, even $2,000 before they ever pay back the $250 because the way the money rolls over. And it really pushes people from being low income to being destitute. And with this, payday lenders all rely on forced arbitration clauses to wipe away state laws that would protect consumers. And they protect both deceptive practices and also just usurious practices. So it's a great point, Senator. Totally agree.
Well, thank you. I think it's another great example of how these forced arbitration provisions are. I mean, frankly, Mr. Chair, I think that they're targeted to take advantage of people who are least able to defend themselves in our economy. Thank you very much.
Thank you, Senator Smith. Senator Van Hollen of Maryland is recognized.
Thank you, Mr. Chairman. Thank all of you for your testimony here today.